Okay, good evening, everyone, and welcome to our Thursday evening seminar. Tonight is the latest in the Adjudication Matters series, and we are joined by Mohammed Haque, consultant barrister, adjudicator, and quantum expert, who is going to be talking about proving and evidencing a claim. As always, if you have any questions for Mo, please feel free to use either the chat facility or the Q&A box at the bottom toolbar, and he will happily answer as many of these as possible at the end. And indeed, if you have a specific question that you would like to ask him, but you don't wish to raise it in an open forum, please feel free to email him on mohammedhaque@silverllp.com. Okay, Mohammed, over to you. The floor is yours.
Thank you. Good afternoon, good evening, because I've just seen that some of the attendees are from previous experience I'm talking are from Asia. So yeah, good afternoon, good evening, and welcome again to the series Adjudication Matters. And we have previously discussed about how to bring a claim and also how to draft a claim and a response, and what to do and what to not to do initial stage of an adjudication. Today's topic, to me, the most important in any adjudication proceedings is evidencing or proving a claim, because you may believe that you have a claim, but until and unless it's supported by solid evidence, in other words, until and unless you can prove what you need to prove, and we'll see what you need to prove, you will not be able to succeed. So, and the other thing, I always repeat this every time I talk, that you have a claim and the claim has been disputed already. So do not expect the other side, the responding party, to say anything which going to favor you. And so do not address them either. Always address the tribunal, in other words, the adjudicator. That's the person you are concerned with primarily, not what the other side's going to say. So coming to the point that who should prove the claim? Obviously, the claimant is to prove the claim. In adjudication, we call it the referring party. And from the rules of evidence perspective, we know, or many of us may know that, the general rule of the legal burden to prove lies with the person who's asserting. So if you are the claimant, you are asserting, and so you have to prove your case. So that's the legal position. However, do remember that this very rule that one who asserts must prove many a times shifts the burden of proof to the other side, because inevitably in almost every case in an adjudication, a referral will be responded, and the responding party, if they bring in a new fact to counter your case, then they will become responsible to prove it. And then obviously in reply, you get a chance to disprove their case by bringing other evidence of fact. But the fact remains that he who asserts must prove, and because it's your claim, you have a basic responsibility to prove the claim. And to prove the claim and its associated matters, we can also we should also bear in mind the not only the legal burden of proof, the evidential burden of proof. And that's actually more important in adjudication than the legal burden, because the rules of evidence in adjudication are not so seriously followed, as much it is important to establish the fact with sufficient evidence. So the evidential burden, rather than the legal burden of evidence, means to be able to present to the adjudicator sufficient, consistent, reliable evidence so that the adjudicator, after receiving the response and comparing the sides, both sides' story and the facts and the evidence relied on, come to a conclusion that on balance, your submission is better than the ones on the opposite side. So that's the evidential burden, providing adequate, sufficient evidence which is clear, concise, not inconsistent, and sustained, or can be sustained at challenge, and reliable, and that the whole purpose of presenting that to the adjudicator is to convince him or her that the facts you have relied on are correct. Now, that brings us to the next question, that what do we need to prove as a claimant? And as a claimant, the referring party needs to prove two sets of, I mean, it's historically classified as to two sets of matters. The number one, I'm dealing with it first, the preliminary matters, is because in your drafting, I've done another session on that, how to draft. You must have seen that there are some preliminary sections. I've referred to it as preliminary sections of your claim. And those preliminary matters needed to be proved, you see. So the first thing, if you go to the title page at the top left-hand corner or in the middle, you'll see that in the matter of an adjudication under the scheme or under a contract, something like that is written. Take a note that every single adjudication in England is either based on the scheme, meaning it's a construction contract as defined by the Housing Grants Regeneration Act, and the parties haven't prepared a procedure for the adjudication. The default position is that the scheme would be applicable, and the powers and the duties and the process to be followed will be under the scheme. I mean, the parties may expressly agree that the scheme will be applicable. The parties may be silent, so they, as long as it's a construction contract and adjudication is available, then it's automatic. As I say, default position is that the scheme would be applicable. But if the parties have had a procedure agreed which is compliant with the Housing Grant Regeneration Act, then so be it. I mean, that's good enough, and the adjudication will proceed under that contract. So please do remember that either you say in your draft it's under the scheme or the contract, and whichever one you say, you just, in your body of the referral, you state why did you say so. And in your schedule, if you say that, let's say it's a JCT contract, and a particular clause in JCT conditions of contract makes it absolutely clear that schemes to the construction contract is applicable for any adjudication under the conditions. So you do refer to it, and I would say it's preferable. It looks professional to me as an adjudicator, and I always do it as a party representative as well. Just take that piece of paper, take a copy of it from the contract, and put it into my evidence bundle. So that's that. Then identity and the status of the parties. Again, if you go to the title page, you'd see that the identity of the parties are given, the name, the address, the registered address or operating address, whatever address it is. And if it is a company, then you just mention it. And even if you do not, because it could be that it's not going to be challenged, so you do not send that copy of incorporation. But I would say gather a copy yourself so that you're sure. Because what happens, and I've had cases involving hundreds of millions of dollars where the wrong party has started it, and there was a merger or an acquisition or assignment, and then someone else has come in. So even though you have an award, technically it may not be enforced. And more, this is becoming important nowadays because there is party funding, even in adjudication nowadays. So if the claim has been purchased by a funder, then that adds more difficulty. And also now the fact that you can adjudicate against insolvent parties in administration. It's to be established that who's the administrator and what is the status of the company at the time you are adjudicating. So these factors needs not only to be written, it's to be established and demonstrated and to be proved as well. And you can rely on various documents from public domain to prove that. In particular, I had only once in my life that the VAT may be an issue, and actually not once, more than once, because when you are claiming VAT, I'll come back to this right at the end. But sometimes it happens that a shift occurs from 20% to 5%, or even for organizations who are charity, no VAT. So if your claim involves a VAT element, you have to look at the VAT VAT you are claiming is the right percentage, and supported by some kind of evidence from the HMRC or some law, or for tax advisor's opinion, whatever that is. Obviously, you got to also prove as a preliminary matter that the site is, assuming that we are talking about an English construction adjudication, that the site is located within England. Mind you, different sets of rules apply if it is even in Scotland or in Ireland or in Wales. So for the purpose of adjudication law, these are different jurisdiction. So the site is important. You might think that, okay, I went to the nominating body and be adjudicator nominating body, and in their form they've checked it, but why rely on others? You see, you can simply state where the site is, and you can prove it from the page of the contract or from so many other ways. So do not think it's not important. I mean, very recently there is a case in the High Court where the parties were not in England, and one of the parties were in Ireland, and they challenged the enforceability, but the court decided no, because the site is in England and construction contract was signed in England, we will have the jurisdiction. So it's very vital to prove that as well. It doesn't have to be like 10 different types of real evidence to prove it. It's very easy, but still it doesn't, it's even, saves your time if it goes on enforcement. And then obviously your claim has to come from contract, and most likely in most occasions, the claims in contract are the creation of the express terms of the contract. And as such, you got to provide the evidence that the term you are claiming as creating the right in favor of you, which you are adjudicating on, or which the other party is in breach, is a term of the contract. And to do so, you got to prove the contract, because it's very, very vital. Many a times when I represented parties, when there are confusion as to which one is the contract, at the enforcement stage, lengthy submissions are made to show that, or to try to establish that the term which is pleaded into the adjudication was not the term under the contract under which the referring party claimed. So it's vital, it's very important to be able to establish the terms of the contract. And it's not an easy exercise sometimes, because what happens, I will just discuss briefly two sets of scenario, two different types of scenarios. One is, or three, I would say. One is a normal tender out. The tender package includes thousands and hundreds and thousands of pages of different things. And then you submit, then there is a negotiation, then there is a pre-contract meeting to summarize things. And then you have a contract being signed. And sometimes it's said that the contract is exhaustive. You cannot go beyond, it's a complete contract. You cannot go beyond the documents of this contract. And in such a case, if you think that a particular thing is part of your contract, you got to trace it back through the express terms of the contract. And sometimes it's not so easy. So many bargains you have made might have been lost because it's not sufficiently incorporated, or even though incorporated, the priority of documents is such that, let's say if it's a JCT, it clearly states that nothing in the schedules or other documents can be brought into evidence to contradict a term of the condition of this document. So it's vital that you establish your contract through proofs. You have an evidential burden, just a mere claim will not do, and be able to tell the adjudicator that this is the document in which I have my contract. Now, the rule, even if it's not stated on the contract book, the supremacy of the contract, the rule of evidence also says that if you have a contract, then an evidence extrinsic to it cannot be adduced. There are, of course, exceptions to it. I'll not go in detail into that, but that's a hurdle. And please make sure you know what parole evidence rule is and whether an exception to that applies. That although there is a piece of evidence you want to rely on, which is not as a contra document, which is not apparently part of the contract, you are still entitled to do so under one of the exceptions of parole evidence rule. And recently, the UK tradition is to disregard extrinsic evidence more. So that's something, it's very vital, because unless something is a term of your contract under which you are bringing the adjudication, you don't have any chance to win. Now, it could be that you have to, your claim comes from a statutory provision. Okay, for example, the goods supplied as agreed, and I'll come back to it again later on, under the contract, failed to correspond or match the description of that particular goods. Now, loads of evidence are thrown at the adjudicators, like, although that is the case, building regs allows this and whatnot. It was the design was the right of the contractor, so he has the chance to change it and all of this. But it's not going to work provided you can simply state that it is an implied term of every construction contract in England that the goods supplied under a construction contract must comply with the Sales of Goods and Services Act as amended, and where a description is attached to a goods to be supplied under such a contract, it has to be followed, it has to be matched exactly And if there is a failure, then the obligation has been failed, and the owner has the right to recover the damage of rectification, or if it happens before the contractor has left totally, or the final certificate is issued, then it has to be removed and changed and rectified by the contractor himself. But do not, I mean, I come across this quite frequently, and understanding even it's prevailing among the representatives that this is a defect. This is not a defect. This is a breach of the contract. And the root right, which overrides many other arguments, simply, if you can show that the provision of a statute requires this to happen and makes it a part of the contract, it cannot be then argued that, oh, okay, even though there is a failure, so don't call it a defect, it is a breach of the contract, and the root comes from a statute, and you got to prove what that is. Similarly, there are common law implied terms, and you got to prove what you are talking about in that. So very recently, I was sitting in an adjudication, and one party relied on an implied term from a general common law position of, I think, of a rental contract decision. And then the other party over-trumped it very easily by showing that in the context of construction, the application of the particular implied term rule was somewhat different, by citing another case law. So if you are relying on an implied term based on a case law or an interpretation of a statute, you got to prove it by providing a particular section of the judgment you are relying on. That's the first one. Then the more important one I've just given, I mean, there are other preliminary matters you need to prove anyway, but I've just given you a broad outline that these are things you have to. Now, even though you do not send some of these at the first instance thinking that it's not, it may not be challenged, but it's always a good idea to create a file. My Excel spreadsheet favorism or biasness that have an Excel spreadsheet, and think what facts have you pleaded in each of the paragraphs in the preliminary section from the title. See what is your basis. Is there really an evidential basis of it, apart from legal basis? Is there sufficient evidence to convince yourself that this is the case, what you're saying? Now, second slide, what needs to be proved? Obviously, the claim itself, including that there is a dispute, because unless there is a dispute, there isn't any claim for an adjudicator. And we know that you have to establish that the dispute has been crystallized. And dispute could be crystallized by one party saying this is the thing, and the other party saying, no, this isn't the thing. Well, in one area, though, you don't have to think of crystallization that much. It's automatic, where you are asking for a smash and grab or an adjudication is based on payment technicalities. In that case, if you do not have the payment notice from whichever party is supposed to come, if you do not have it, then if there is already an application which is permitted under a valid application permitted under the contract, that becomes the default notice, or you have given a default notice and that has not been responded to, then the sum applied for either in the application or in the default notice served after the time period by which the payment notice was to come, the sum stated therein becomes notified sum, and the notified sum must be paid unless the owner or the paying party, the payer and his representatives issues a valid notice to pay less notice of intention to pay less than the notified sum. So if your case is on that, in that case, that in the absence of either of them two, or invalidity of a payment or a pay less notice due to time or something else, in that case you don't need to wait and send another round of letters stating that I'm going to bring an adjudication. No, that's good enough. Once the time period is over and there isn't a either a notice, or B, A, payment notice, no pay less notice, or C, either of them were invalid, and there is a notified sum established through either the payment application or default notice, you don't need to establish the dispute crystallized. Other than that, in every single matter, there has to be a dispute which has been crystallized. It's very easy to discharge the burden. Obviously, if you have a clear denial in any form, in a meeting minutes or in an email or in any document or a correspondence, that serves the purpose. If not, then you know that one cannot omit endlessly and still say that there wasn't any dispute. But one thing, please remember that you have to have some document which shows that, or a witness statement if you don't have any, which shows that the matter in dispute has been communicated to the other side, at least in broad sense. Further facts and figures and detailing can be possible at any stage, but at least in broad sense that has been communicated and either denied expressly or denial can be inferred from their conduct. Of course, the correct adjudication nominating body has been chosen. This is another problem. I've seen many a times jurisdictional challenges come in because how it happens, because there are uncertainties regarding which document is the contract. So then in different documents, you see different things. And then even if there is a certainty, you haven't crossed or ticked the relevant section because let's say in JCT, you have 3 or 4 subsections, which is telling us which A and B you are going to prefer. Now, if you do not cross and tick, then one scenario comes. So, and that quite frequently happens, you know. I've seen always this type of things wrongly done in contracts. So it's always better be, and especially if you are a party representative, if you don't look at it, seriously at the very first day and gather the evidence, and somebody says that, oh, I want to go to Rick's, Reba for that matter, and you take it for granted that that is the body appropriate, many a times you'll see that by a single letter, it's established that that's not the A and B. There was a person first to be approached, or a number of persons to be approached, and because agreed list is there. So you may have difficulties and your claim may be lost, and it's very, very insulting in front of the client that you do not have these basics being checked. So how do you ensure that you have done the thing right? Only one way. Have your clear evidence from the contract, work around it, and as I said, in a spreadsheet, okay, which one A and B shall I go, and what evidence do I have for my decision that I'm going to that particular A and B? Now, apart from that, we come to obviously the basic obligation to prove the relevant facts. Well, although it's an industry term among ADR claim representatives, that relevant facts, we got to actually, in order to understand this, we got to go back a step behind, you know. The relevant facts concept comes from the concept of facts in issue. facts in issue means the claim you are making would inevitably be a creation of law, and by this I include the contractual terms between the parties. Okay, so your claim is either the express terms of the contract or the implied terms of the contract, because of some statutes or something, entitles you to something or imposes an obligation on the responding party which it fails to perform, either completely or misperformed it. That's why you are claiming. Now, what you have to do to understand what evidence you need to provide, you got to go to that provision. For example, if you are looking for some money because a variation was not appropriately valued, okay, very common thing that a variation has not been appropriately valued. Now, you got to be sure and establish that this was a variation first. And in order to establish that, every single contract, let's say a JCT, the term variation is a JCT concept, so I'm talking about JCT, that there was a change, and that change was such that that necessitated a valuation. It was not for information only or no value change, and that valuation was not carried out. These three basic things. Now, it has to be a change first. Now, as soon as you go to that provision of the contract, you find out when and what is a change. Okay, there are lists, relevant events, a change, other things like any change in the statutory order, including, of course, every new planning permission is a statutory order. So a change in the planning is a change if it had happened after the base date. So you have a chance. And matters of the utility bodies, they're also statutory undertakers. So there are lists of relevant events and other things from which you know what is a change and what is not a change. And you would also know that under JCT, and it's a fundamental flaw I've seen among the clients, that they don't understand it really, that the informal requests by the employer or their side is not a variation until and unless it's documented properly. And it could either only be an architect certificate through which you can prove that this is a change, been instructed, an architect's instruction or a certificate, and or if it's an informal one, a contractor's variation instruction. There isn't a third way. There isn't a third way at all to establish that there was a variation. So even if you have in actual did something, you may struggle to prove that it's a variation. And if your opponent party is serious enough, they will raise it that this is informal and it has got no value in my eyes. They have done it, let them take it back. As simple as that. I didn't ask for it. Now you stand a chance. If you do not have any one of these above, it's not that it doesn't happen on a regular basis, it does. You may have a case if you can establish that it was at least requested. So then you get into an era of oral evidence, maybe. It was requested at the site level by the operation team, and at their request, you have done it and they have taken it back. So if these three things are established, then you stand a chance. The adjudicator will say, I'm not bothered about your formality requirement. You have asked for it and you got to pay for it, provided it's a change. Now, provided it's a change, you got to go to the basic requirement that what was the scope. So you come to an evidential document of the scope where it's defined. And then you come to extrinsic evidence of the scope, because it could be that something is part of your scope but was not added to your contract document. It was in the contract tendering package but not added to your contract document, and there isn't a clear reference to that either. That's where it becomes tricky to find out what is relevant fact directly hitting that point. Deliberately, I used it because there's a prevailing tendency to use this phrase, relevant fact, but there is no relevancy of a fact. There's no relevancy of a fact until and unless it relates to a facts in issue. And a facts in issue is that fact which is dictated by the requirements of the particular term under which you are claiming. So you've got to first establish which term you are claiming under. Is that an express term? Is that an implied term? If it's an express term, is there a procedure or an interconnected term? So you set up the pages or extracts of the contract where it interlinks, show in a page in your evidence bundle how it interlinks into the flowchart type diagram exercise, and then bullet point the requirements of each of them and see how you're going to tell the adjudicator, not the other side. You see, don't be, oh, well, why this is saying this, I'm shocking, surprising. This is not going to do anything. Go to the material piece of evidence that's going to convince the adjudicator that yes, this requirement is established because the evidential burden is discharged, meaning that there is sufficient, reliable, consistent, clear evidence, which establishes that the story this claimant is trying to tell me is correct. Now, you might feel, and I've seen fellow colleagues right from the day one in my legal practice and my quantum practice, they treat it as a daunting thing. It's not. If you exercise it, you'll understand your case is either good or bad, because you cannot create a case. It has already happened. And the types of evidence you can present to an adjudicator are only three. Oral, through, of course, in adjudication, primarily through witness statements. Documentary, because every single thing at least theoretically, every single thing in a construction project is documented. And then real as well. Some examples, some samples, sort of thing comes in. I will get back to real again, but obviously one by one, oral, documentary, and all these will be. Now, there is a trick. If you are struggling to present cogent evidence a lot, okay, why it is sometimes in litigation, we try to rely on discovery, meaning that that the other side has something in their disposal which is going to prove your case. It's not available in adjudication. So, and many people, like even legal practitioners, I see in, let's say, the SCL after lunch chat among professionals, oh, something, discovery is not available in adjudication, it's a matter. I tell you, this has no impact on adjudication, lack of discovery. Why? That if you want, and if you convince an adjudicator that a particular document is going to prove your case, and if that is not supplied, then the adjudicator has the right to draw his inference. And as such, parties would love to share, rather not to, because the adjudicator will say your case is not credible, because when the claimant said that, although this is the case, the document which proves it is in the disposal of the responding party, they asked for it and you didn't provide it. So that's that. More importantly, and that's the main thing, I mean, whatever I've just said a minute ago, let's forget that. The scheme and the Act, both 108 and paragraph 13, provides a clear power to the adjudicator to take initiative to establish the facts. It's a semi-inquisitorial power, okay? Why I'm saying it's not a full inquisitorial power, I will come to this in a minute, but remember this. This is the strongest tool you have in your hand if you are struggling with evidence which are inconsistent, which you cannot reconcile, and face a lot of problem, and you have less contemporary documents. What can you do? You can ask the adjudicator to hold a meeting. We don't call it hearing, to hold a meeting. Now, remember, the adjudicator has the power to do that anyway, but the adjudicator doesn't need to, okay? And if it's not raised, he may not be bothered, okay? Because not only he may not be bothered, it may be that he'll be viewed that he was running on his own frolic. So he was bringing in a third-party case. So he has a danger as well, not to start something which the parties didn't ask. But you have that tool in your hand. Make a request to the adjudicator under paragraph 13 that, sir, you have the power and the right to investigate and find out. Please organize a meeting so that we discuss it, and we will be able to resolve it through witness statements, or please conduct an inspection and decide, do a site visit to find out yourself, you're an experienced professional, or appoint, and it's a very tactical move. I've been appointed a couple of times as a tribunal appointed neutral quantum expert to go and find out what the quants should be. But this was not a brainchild of the great adjudicator who asked for it. You know, it was an issue of millions and millions of pounds. So nobody took an offense for a 25K report to resolve it, because the adjudicator didn't have the time to do so, or didn't have the expertise to do so. He was it was a design difficulty and defects, and quantum of rectification was an issue. So it was beyond his capacity. And one of the parties raised it and said, if we are ready to bear the burden of paying for it, one thing, first up, remember that the 28 days time slot was then gone, because the parties had to agree with the adjudicator for a reasonable time extension. It may not be possible in small adjudications, but it's getting more and more popular in the bigger ones. And so the adjudicator has the right to have a site visit and decide on his own. He may seek, if raised by the parties, that an investigation is needed, he can do it at the request of one of the parties or both, and ask the other party what's the view. And thirdly, he can be requested to appoint others to gain a neutral view. You know, so why do you need discovery? You see, if there is a problem, a defect into the construction, you know, is it not possible for a particular, and he can even have tests run. You know, you can ask the adjudicator that, you see, we're ready to provide and facilitate the matter, and please order that a test to be done. Initial payment we are making, but if we win it, you know, we agree that you ask the other side to pay it. You know, that's the reason Section 108 said that you may have an agreement to recover your party cost as well. And then if the other side says, no, there shouldn't be a test, it's not needed, this is proof from their statement, the adjudicator has the right to infer. So use your tool under the scheme, don't get bogged down, it's not a litigation, so we don't need discovery, okay? Now, I've already started touching on it, that factual evidence is not available, so what we can do, we can go to opinion evidence, meaning employing the experts and similar things about it. And I will touch upon, let me check the time if I have, yeah, I still have time. So I'll have, I think I only have Yeah, I only have one more slide, so I will touch upon this. This is vitally important to me. That if you have asked for, because most of the adjudications are actually, unfortunately, I'm an adjudicator myself, either lost or won because the silly behaviors of the parties. You see, rather than using the tool of paragraph 13 and organizing meetings and inspections and third-party neutral opinions, people start throwing bundles of irrelevant information and documents, and thereby create inconsistencies, and their primary case fails because of later silly documents been sent. So how I wanted to let you know how an adjudicator work in a scenario like this. He weighs the conflicting evidence from both parties. Before that, he checks the evidence is consistent from the party who's relying on and sufficiently corroborated. And I'm touching on three different areas here. First up, if there is a meeting and oral evidence is, the witnesses are giving oral evidence. So when it's most likely to convince the adjudicator that an oral evidence session should be held, it's not, for heaven's sake, it's not a hearing. So do not bring two barristers and start cross-examination on that. No, please ask the adjudicator that you are looking for it because there are conflicting statements on the matter from the parties. And it's best that it's face-to-face resolved. So what happens when an experienced adjudicator sits in front of two parties who are all construction people, the adjudicator is the same, and they start talking about it, adjudicator actually asks questions and to find out, to gauge the depth, who's saying what, the way they're presenting, okay? So he would try to sense that if the witness appears truthful or honest, and it's a factual evidence, or they're trying to develop a view in favor of their own client. The second is not very helpful because adjudicator knows what view he's going to draw from it, but he's looking for the conflicting facts between the parties, which one is correct, not an argument from a witness, okay? Now, if there isn't a contemporary record, the best thing is to bring in those site people and the managers and their recollection. You know, if they can recollect, how they can recollect, everyone should be told all the time that at least maintain a small diary of the events of the day, so you can go back. A simple scratch in a piece of paper might help you a lot. So these are issues that the adjudicators have in their mind when they hold a meeting. And I would say, even as a party, I've worked, and still I work as a party representative, truth does come out. When people easily can lie through statements, it's not so easy to say so in front of the adjudicator when they're directly challenged. All right, Smith, you're saying so, but do you remember the meeting at site on such and such day? What happened on that meeting? Why did you say this? Then they have to say, I'm sorry, yes, I said that, but later on I realized I didn't say the right thing. There you go, you got your case. Similarly, if it's meeting is not your preferred mode because maybe the people are nervous or you don't feel confident to go in front of and face a challenge, it could be a documentary evidence. As soon as you get to a documentary evidence, please, for heaven's sake, remember that the evidence should look reliable. Do not send one email on a trail where it's evident that you have doctored it, so that there are other parts. It gives a clear indication even to the other side that they go back to the trail and find out that in the 2 emails below or a paragraph below, there is something which goes against you. Do not rely on something like that. Even if you want to, just take a printout of that particular screenshot or whatever, that particular email you want to show. Do not show things where it is clear that you have deleted some part of the email. You won't believe how many times it happens. I love them. I love them as a party rep. I love them as an adjudicator. So the document must look reliable. If possible, show the original as well. And if it's a record, it's fantastic. Now, if it's a record at a site level, it may not be legible. Then type out in a separate page, make like a duplicate of it in a typed format. That really helps. It's no good to send to an adjudicator tons of illegible documents that have been photocopied. You won't be able to get anything out of them, And then additionally, as soon as a document is sent, please send a testified witness statement that this document is this, and give an explanation of why that is sent. And obviously, as I said, it shouldn't be inconsistent. And either when you are providing oral or documentary evidence, do remember that corroboration is very important, because rarely one document is sufficient. So if you have more than one supporting each other, you get your case. So that's about the other two, the oral and the documentary one. I come to opinion evidence. Obviously, opinion evidence is where you do not have any other evidence. Please, for heaven's sake, do not appoint an expert who tells the adjudicator that my experience from North London last year from such and such building, I know that this is the cost for a swimming pool. Please don't. Please appoint an expert who can gather the price, either from contractors quickly or from an assessment of his own, looking at the spec and the quantity. Okay, it's no answer that if I worked in 3 other similar projects in North London, and in my experience, this swimming pool element should be valued at such and such. No adjudicator is going to buy it, because they're all construction professionals. You see, please go to at least such a person who can create a value from the specs and from the quants matched to the contract, and then does a sanity check with BCIS or something similar to it. Only then it becomes credible. Don't just send an opinion statement for the sake of it, and the guy has got lots of letters behind. It's not going to sell. And then the other type of expert reports are explaining and reconciling evidence which are not so apparent, or maybe even has inconsistencies. You need a higher type of people for them as well. So if you really want to win, also remember that you may have to go to more than one person. For example, an architect or a building surveyor really calling a defect, because if your quantity surveyor gives an opinion, they say defect is not going to work. And such a person should not just say, I've had a look and I'm sure from my 25 years experience it's a defect. He should rely on independent material evidence like testing and other inspection reports and whatnot with photographic backup. And then the quants should be taken by a quantity expert, and it should be priced with a proper market value approach, keeping the spec and connecting it to the market data, not by my personal experience. Other than that, you stand no chance. Also remember that although conflict is not a big issue, you can have an expert who is part of your team. Still, it's better to have an independent expert. And I have discussed the rest, obviously. So the last one is how to prove your entitlement of interest. And you have done the same remedies into the notice and the referral. Interest is either into the contract or the Late Payment Act. So make sure which one you are talking about. And the same disputes are submitted. Please compare your notice and your referral into the redress sort section. That's all for today.
Okay, thank you very much, Mo. We have got a couple of questions, if that's okay.
Yeah, that's fine.
The first one says, What if one side introduces witness statements that differ greatly from what the same people recorded in site minutes?
Well, that's a very good thing, because if a site minutes is different, and we get it quite often, that if a site minutes is different from what the witness statement is saying, by all means, when you are responding, flag it up and give the site minutes. You win your point.
Okay, so that's a positive.
It is always, I mean, if you're in dispute, I mean, interestingly, people get frustrated, and that's the first problem. They get emotional. How on earth Steve could say so because he said something different than minutes? You lose your ground. If somebody says something in an oral statement during the adjudication, which is different, which is said differently in a very polite manner, we lawyers say that he had a previous inconsistent statement, you know. Right. Then it's your chance, it's your opportunity. Wow, you know, so you can discredit that person.
Okay. Someone else here is asking, practically, at what point is a dispute defined that can reasonably lead to adjudication?
Can you repeat it?
Of course. Practically, at what point is a dispute defined that can be reasonably, I'll start again, I'm sorry, I've got the wrong teeth in my head. Practically, at what point is a dispute defined that can reasonably lead to adjudication?
Well, a party one, well, I will sorry, if it's a payment dispute and you are basing it on payment technicalities, meaning the payment terms under the AGCRA, as soon as you know that the payment notice is not there, you can go ahead. It doesn't matter that the final date of payment has not come through, you know. So at the earliest, when the dispute is crystallized, if it is a valuation dispute or some other dispute, then as soon as you have pressed the point, because the Act says any dispute can be adjudicated at any time, and every difference between the parties is a dispute. So as soon as you say that, I am entitled to an extension of time, and the other side said, no, you are not, that's it. Or you applied for an extension of time and the other side is not giving it and keeping silent, that's it.
Okay, that's great. Right, that is the end of the questions that we have for this evening, so thank you for the clarity there. I'm sure that's helped. And as always, we've got another one with you. The next one in this series is next month, the 19th of May in the evening. And that's the do's and don'ts on adjudication.
Yes.
Perfect.
I'll come back to some of the evidential points in do's and don'ts, because adjudications are mostly lost or won on evidence.
Yeah.
These are like mature thing to think of.
Yeah. Okay. And we're also just to let everyone know, you're going to be starting a series of podcasts shortly as well, aren't you?
On case laws first, yes.
Yeah, on case laws. So we're looking forward to those. In the meantime, our next seminar will be next Wednesday, and we have the problem of subcontracting that's being presented by Richard Silver. Is that a question just coming in? No, that's someone saying hello. That's fine. If you would like problems with subcontracting, if you'd like a place on this one, please don't hesitate to drop us an email at seminars@silverllp.com. Thank you very much, Mohammed, for your time. As always great to hear from you. Thank you, everyone, for attending, and we look forward to seeing you all again soon. Have a great night.
Bye, everybody.
Thanks.